Continuing education knows that at the end, students want to graduate, and we can help them do that because we take the time to really listen to their needs and we understand all the different options that are available across the campus for them.
We don't take a cookie cutter approach. We realize each student comes with their own story. So whether it's a part-time student looking to complete a degree program or someone just looking for online courses, we're there to connect them to the resources of the university.
All right, good afternoon now, ladies and gentlemen. Thank you very much for your attention. My name is Eric Johnson. I am a district court judge for the state of Colorado, currently seated in the 2nd Judicial District in Denver. I am here to moderate the panel today of what to watch from the Supreme Court of the United States. I can feel the anticipation already in the room, and I can almost sense the blood pressure rising. Folks, one of the wonderful things about the conference that we have here is, we have an amazing opportunity to learn, to listen. And note that I use the word listen, not just hear. And when we listen to something like this, I can imagine we all have personal feelings and thoughts. But I think one of the strengths of a panel like this, and one of the strengths a conference like this has to offer, is to give us the opportunity to really hear and listen to opposing sides, to understand where they're coming from. And this will, in the end, help you understand the people who disagree with you and realize that they're all not stupid or ill-informed or just wrong. It'll actually help you if you truly understand another side's position. It'll help you finely tune your own positions and make them better and stronger. So I really hope that's what we're going to get. We are, these panelists, you guys are very lucky to have these two panelists with you to talk to you and share their thoughts and insights. And I know we're not going to have any problems. This is not a forum for protest or rudeness or anything like that. And I know we're not going to have any problems with that. And I thank you in advance for your civility. And yeah, I have a lot of faith in human nature, and this is gonna be a good, fun, rousing discussion, and you guys will have time, I believe, about 20 minutes at the end for any pointed questions you may have.
You're starting to jinx it on the audience.
All right, anyhow, let's see. We'll go from your left to right. So on my right, we have Mr. Will Trachman. I'm sure you've been able to read his bio in your materials, but a couple of things you may not know. He is from the jewel of the Central Valley. He is from Fresno, California. In law school, he won awards in parliamentary debate. He clerked for Judge Harriet Hartz in the 10th Circuit in Albuquerque, where apparently he was quite a shark at clerk poker games. And lastly, apparently he has a budding career, a budding gig as a stand-up comedian. Right. And now to my right,
I told you that in confidence.
Cora, open records. All right. And to my left, to your right, Ms. Lisa Graves. I'm sure you read up all about her. At some point, I do have to ask her about her appearances on a radio show called Deutschland Funk. But she also was an award-winning college debater while she was in university. She also starred in 13th, the documentary, if anyone saw that. Had a significant role in 13th. And finally, she is an artist who does abstract painting and graphic design work. So our panel here really is to start off with a rundown of what we see on the Supreme Court's docket and implications for recent or pending decisions. I want to spin things off just a little bit to start, though. How many non-lawyers are in the room? All right.
At least
Congratulations.
my condolences. Yeah.
In real fast, the Supreme Court is full of a bunch of little stories, and after this, you'll start hearing much less from me. But in 1970, two lawyers hiked 6 miles into the woods to find Justice William O. Douglas in Portland, because they wanted to restrain the police in Portland, Oregon, from using violent tactics to quell protests. So they hiked miles into the woods to find Justice Douglas, had an impromptu oral argument, and asked him to make a decision on this issue. And he wrote it on a sheet of paper, stuck it to a stump with a knife, application denied. What is going on with two lawyers walking up to a Supreme Court justice 6 miles in the woods? Folks who don't know this, there are two main dockets that the Supreme Court deals with. You've got what is called a merit docket, which is the ones you think about that are fully briefed and argued and they issue formal opinions. The other is what is called the shadow docket. And the shadow docket is made for procedural issues and to handle injunctions in cases of emergency situations where there would be irreparable harm. The shadow docket has been getting a lot of press lately, and the expanded use of the shadow docket to make important decisions. And that's where my little curveball here, I wanted to start off, and I'll start with Ms. Graves and ask her about her thoughts on the current use of the shadow docket and what it portends, and good, bad, or otherwise.
Well, Judge, I really appreciate that question, and hello, everyone. Thank you so much for coming out this afternoon to hear more about the Supreme Court. As the judge mentioned, the shadow docket is not a recent phenomenon, but it's something that only recently has received some real attention from some excellent legal bloggers who've been talking about how much of the court's business is handled through the shadow docket. The shadow docket, meaning these cases are not briefed, they're not argued before the court reporters and the people who cover the court aren't there covering an oral argument. It usually doesn't make the headlines until the decision is issued. And I guess a couple things I would say about this, which is, one is the U.S. Supreme Court receives these petitions. They're called cert petitions, petitions for certiorari, which are basically appeals. Those come from the federal courts and from state courts. And each year, the U.S. Supreme Court receives between 8,000 and 9,000 requests to hear a case. That is not just a request for the most part. Those are very expensive briefs to even file in the first place. The procedures for the court cost a lot of money to make sure your papers are filed with the right color paper, the right font, all the pieces, just to get your petition in front of the court. Under Chief Justice Roberts, the U.S. Supreme Court has been hearing fewer and fewer cases per year. So right now, the U.S. Supreme Court is hearing in oral argument only between 60 and 70 cases. So basically, less than 1% of the cases that are coming to the court saying, please resolve this matter, please issue an opinion, the court is only choosing 60 to 70 cases for oral argument, for full briefing, for amicus briefs by groups like the group that my panelist here helps lead. And so an enormous amount of the business of the court, these decisions to either deny certiorari or overturn a matter summarily, basically without an oral argument, are happening behind the scenes, not really they're in public in the sense that there's a decision that's issued that you can see on the Supreme Court's website, but there's not the type of argument that is happening. Now, within that 60 to 70 cases that the U.S. Supreme Court chooses to hear each year, they're chosen based on a thing called the Rule of Four, which is, it's a 9-person Supreme Court. That's not set by the Constitution. It's just a matter of practice and tradition over these last more than 100 years. But if 4 of the 9 justices vote to hear a case, that gets the case lifted out of this sea of petitions and into the queue for oral argument. And so there's been a lot of concern in recent years that major substantive decisions are being handled through the shadow docket. And I think it's concerning in part because the U.S. Supreme Court, with more technology, with at least 4 clerks for all of the Supreme Court justices, are hearing fewer cases than were being heard in like the 70s and 1980s. So you have a court that has more technological capacity doing less. And those cases that it's hearing, the ones that it chooses to hear, almost none of them are mandatory jurisdictions. So under the US Constitution, if there's an argument between states, like for example about the control of the Colorado River and who gets the water and how the water is decided, those sorts of cases, a state versus state case is a mandatory jurisdiction, but almost all of the cases that US Supreme Court decides to hear are voluntary. So they're picking to choose a case on abortion. They're choosing a case on religion. They're choosing a case on voting rights. A circuit split, meaning there's a difference of opinion in these appellate circuits, may come up. It may be manufactured by the parties trying to generate a split so the court takes the case. But for the most part, this court is operating almost as if it's a legislature deciding that this year we're going to be taking up affirmative action. This year we're going to be taking up abortion. And so that's what's happening in public in the oral arguments. What's happening in a less public way is this shadow docket. So I guess that's what I would say to add to the conversation.
All right, and as we, before we shift over, what types of things is it that we are talking about? The Supreme Court, through their shadow docket rulings, has recently allowed the executive to halt millions in teacher training grants. They paused an order that reinstated fired federal employees, and they blocked a federal judge's order that would have required the government to return a Maryland man who was erroneously deported. So these are the types of things that happen, without the briefing, are happening without the full briefing and argument, in what we call the shadow docket. Mr. Trachman.
Yes, so let me comment on the things I agree with. So it's true that the Supreme Court is made up of 9 justices who have limited time, and their term goes from the first Monday in October to June 30th of the following year. So if they're spending more time on emergency petitions, they're going to spend less time on merits docket cases. So that's just true. As a matter of fact, there's only so much time in the day. These are justices who are bound by a term schedule. And so if they do more on the emergency docket, they're going to do less on the merits docket. So why is it important to talk about what has been called the shadow docket? So the shadow docket is not a thing. It's not a title of anything that the Supreme Court publishes or has in its rules. It was developed in a law review article by a law professor. And what we're talking about is the emergency orders list. And I agree with my panelists that you have to have an emergency orders list of some kind. Maybe it doesn't have to be 100 cases long, but you're going to have emergency cases like death penalty cases where urgency is just part of the case. So someone whose execution is upon them is going to have a request for a stay of execution. If the court asks for merits briefs and then takes 6 or 7 months to write its opinion, the person will have already been executed by that point. The case will have not reached a decision in time to actually offer that person any relief. Another point is that the merits, the emergency orders docket itself doesn't have a political valence to it. So the judge just pointed out 3 instances where the court granted a stay, that is, they lifted a negative order to the Trump administration. But let me talk about a case that I just lost 2 weeks ago in the Supreme Court, which had a procedural history before that. This involves what people have referred to as the ghost gun regulation. It was promulgated by the Biden-Harris administration in 2022. And before 2022, hobby kits, where you could get a hobby kit in the mail, assemble it in your basement, and then have a working firearm at the end of the day, were not regulated as firearms. But there was a regulation that the Alcohol, Tobacco, and Firearms Department had that said it could regulate firearms. And so it expanded its own authority and said that we're going to define these kits as weapons in and of themselves. My firm challenged that. We prevailed at the district court in Texas. We prevailed when the federal government appealed. And at that point, what did the Biden-Harris administration do? They appealed to the U.S. Supreme Court asking for an emergency order that this regulation had been halted by federal courts, and thus it was open season on ghost gun kits. And so they applied to the U.S. Supreme Court, and in a 5-4 ruling in 2022, obtained an emergency order halting or lifting the injunction against the regulation that had been promulgated. So these orders go both ways. I think we're going to see over the next 4 years that the emergency orders docket generally benefits the administration in power, because the court gives quite a bit of deference to the federal government. That's why the Solicitor General, the chief lawyer for The United States often gets oral argument time when he or she wants it. It's also why they are often filing briefs. And I'll correct one thing, which is that emergency orders cases aren't unbriefed. Of course, the briefing time is much shorter because it's an emergency, so you might only have a few days as opposed to a few months, but they're briefed and there are decisions. People have complained, and I think this is a fair complaint, that the decisions aren't as instructive or illustrative as the merits briefs that often contain 10, 20, 30 pages, especially for those who would deny the petition. They might not say a thing. But Justice Coney Barrett has occasionally said, look, don't criticize us until you've read the opinion. And I tend to agree with that it's easy to say you should have taken more time or you shouldn't have gotten involved in this issue. But until you read the opinion, it's really hard to cast a wide aspersion on all of these opinions. And again, my point is that they go both ways. You have to have a docket like this, and it exists because presidents of both parties want the Supreme Court to step in and do things quickly, because otherwise the moment will have passed.
Well, and so Ms. Graves, what do you think about the concept of judicial restraint and that a court should not be entering these types of orders unless it actually is an emergency, unless it actually is shown that it will have irreparable harm? Has there been a change in that regard?
Well, I'd love to see some judicial restraint, I suppose, given what we saw with the immunity decision last year, which was the opposite of that. And I'll talk about that more in a bit. I do think, as William, do you go by Bill or William?
Will.
Okay, Will. I was wrong again. As Will pointed out, on the emergency docket, for example, for a death penalty case or something, there is briefing that comes in, but it's not the full type of briefing. It's not the full set of amicus briefs that you get with a case that is approved for argument. And the court could move a case quickly, as you probably saw last year when the Colorado Supreme Court issued its decision under the 14th Amendment under the Insurrection Clause, and suddenly the Supreme Court sprang into action to issue a decision quickly after briefing, and issued a decision to overturn the well-reasoned decision of the Colorado Supreme Court, and did so just in time to make sure that Trump was on the ballot. But then when the case was pending about the criminal charges in Washington, D.C., the court took that case, slow-walked it to the very end of the term, the last time for oral argument, issued it on the last day of the rulings, then issued what I believe to be an anti-counter-constitutional decision. But let me get back to the question you asked, which is this question of how the court is viewing emergencies. What happened this week in this case involving a Maryland resident who's married to a U.S. citizen, who has U.S. citizen children, who was summarily removed from the United States and taken to basically a torturous prison in El Salvador. That case was coming up to the Supreme Court. There was a stay in place, and the court lifted that stay. The court is basically allowing these procedures to go forward, and the court, in its unsigned opinion on this shadow docket case, asserted that the proper way to proceed is through habeas petitions, basically. Although, as the dissent pointed out, the U.S. Constitution has not been interpreted that way to only have habeas petitions be the exclusive way for someone to get a case like this before the court. And so what happened was, rather than assessing the actual harm to the individuals who are impacted by these summary orders to remove people out of the United States without due process, the court is allowing that process to continue until a later time. I think on the merits, the right thing for the court to do, the right thing for a just court to do, would have been to allow that stay to continue until this issue is fully briefed, and in this case, fully briefed. That's my opinion. I think it was improper and inappropriate for this court, for the Roberts Court, for the majority on that Roberts Court, to lift basically the proceedings in this case to allow this process to continue, while it appears to be in deep defiance not only of the actual statute that they've invoked, the Alien Enemies Act, but also in violation of long-standing interpretations of the U.S. Constitution, which by its terms, in at least two places, talks about the fact that no person shall be deprived of due process of law. No person. And when they meant citizen, they said it. And when they meant person, they said it. And this is a person who has ties to the United States and some of these other people as well who've been removed, and their rights have been outrageously, summarily destroyed in the fact that and I just have to pause here and just add this one thing. This prison in El Salvador, where we are paying through Marco Rubio's agreement to pay El Salvador to take these prisoners, this prison puts 150 people, like the size of this room, into a space almost the size of this room, with 2 toilets and 2 sinks and 4 tiers of metal beds with no pillows, no blankets, no mattress. They have 24-hour light shining on them at all times, and they have barely an opportunity to actually get real sunlight or even talk to lawyers. This is an abomination, and the court, by lifting this order in this shadow docket, is allowing that process to continue until further briefing takes place.
All right, Will, so Will, I'll give you the last word on the use of the shadow docket, and has there been a qualitative change, or are people just paying attention to it more now?
Well, I won't count the applause for my panelist as an audience interruption. These are all really good questions. Let me address a couple of things. First, I'm getting confused as to whether the criticism is about the shadow docket or just opinions that we don't like and don't agree with. Because initially we were talking about how Trump has been winning a lot on the shadow docket, but then the next 2 examples were the 9-0 unanimous opinion that President Trump could be on the Colorado ballot last year. That was not a shadow docket case, and it was unanimous. And the other was the immunity case, which was also not a shadow docket case. That was fully briefed and argued. The argument was very long because the Supreme Court has been lengthening these arguments due to all of their questions. And then an opinion was issued at the end of the term. So that's not the shadow docket. Those are just decisions that you wish went the other direction.
If I could just interrupt for a second, I'm so sorry, Will, but just to say, I was using those as an illustration of the court's willingness to go fast when it wants to and to go slow when it wants to in the terms of this emergency docket versus how it handles other cases. I wasn't suggesting at all that those were shadow docket cases, just to be clear.
But then what are we really criticizing? We're not criticizing the emergency orders docket. We're saying they ought to take as much time on Trump cases as they would on any other case. And obviously that's just not going to be possible. The decision about the Colorado ballot was actually imminent, right? We needed to know whether or not Trump could be on the primary ballot last year. And so maybe they wrote quicker than they otherwise would have in a standard criminal case or environmental case. But again, fully briefed, fully argued. They took their time analyzing and letting that issue percolate before intervening. They didn't have to let it get all the way to the Colorado Supreme Court. They could have decided, or even earlier, this is such an important question, we want to get involved sooner. The last example was about this 5-4 stay that was lifted last week about the individual who has been deported, I think, to El Salvador. And all of you at the beginning raised your hands, or many of you raised your hands, that you're not a lawyer. And let me just say, lawyers can be, some of the hardest people in the world to understand, because we're not supposed to care about how sympathetic someone is when they go to court. The question is, are they injured? Do they have a legal claim? And can the court remedy that legal claim? And the 5-4 decision was actually a 9-0 decision, as Justice Kavanaugh pointed out, saying individuals are entitled to due process before they're deported, but not in this court. The case should have been brought in Texas as a habeas matter. And so that was the issue that the court divided on 5-4. Now, obviously that's not going to be very satisfying, right? But the point was this was a procedural decision, not a question of how the conditions in El Salvador are, not whether they deserve more space. The issue is not whether or not due process is allowed or if someone is entitled to it, but it was where. And the court decided it's a habeas corpus action, as we all probably studied in government, and it has to be brought in Texas where the individual is. You can't bring a broad challenge about everyone's due process rights just in Washington, D.C. Procedure, yes, probably unsatisfying given that most people are going to care about how sympathetic the facts may be, but that's what the law was. In many cases, the law is unforgiving. You have to meet those standards. Are you injured? Do you have a legal claim? And can the court remedy that claim? And if any of those three fail, you're going to have an unsatisfying result. Most people would call that a technicality, but that is, at the end of the day, what the law is about. We take reason and we separate it from instinct, from the natural impulse that we think this person ought to have a different situation. We actually have a court system that is impartial and doesn't look at those things before deciding cases.
All right, I wanted to wet everyone's whistle on this concept of what we call the shadow docket. Now everyone's got homework to go home, and you can start paying attention a little bit more to the shadow docket. Now the description of this panel indicated that we would be talking about a rundown of what we saw on the Supreme Court's docket, as well as implications of recent or pending decisions. So what I'd like to do now is kind of shift gears and to Ms. Graves. Oftentimes the Supreme Court will take a bunch of cases of a certain type because they're trying to get to a certain direction on something. Can we read, in reading the tea leaves, the cases that were accepted this term, can we read anything into where the court is going in the gestalt based on what they've decided this term?
Well, that's a good question. You know, the court has the docket that it basically planned out, in essence, at the beginning of last year, coming into it's the court term from October to June, and then it has a whole series of new cases that are emerging as a result of this administration's dictates. And so, you know, the court's term is very much sort of up in the air, in essence, because there are so many cases coming up challenging these edicts from Elon Musk under Trump, under claims of executive power or authority to unilaterally fire people regardless of collective bargaining contracts, to gut agencies notwithstanding the commitments of the Congress in terms of the budgets that are passed by Congress, that are signed into law by presidents. So there's a whole series of cases coming that if you had asked me in October what the docket looked like, I would say it looks very different than it looks now. It looks now as though the court is going to be handling a number of cases assessing these extraordinary assertions of executive power. But there are some cases that the court has taken that appear to be designed to extend some of the cases that it has already been pursuing in its effort to remake American law, to basically reverse major precedents of the 20th century and the 21st century. For example, we're going to see a decision, I think, this year. I mean, it's up for all the briefing is in and the arguments are part of this process. But there's a case that has come out of Oklahoma where Oklahoma has decided to direct taxpayer dollars to fund an entirely religious charter school, basically to have people's tax dollars fund religious indoctrination. That builds on a previous set of cases that this U.S. Supreme Court, the Roberts Court, has issued that has tried to tear down the wall of separation between church and state and reverse longstanding precedents that really, in many ways, go back to our founding. In the colonial period in the United States, there were states that were, in essence, theocracies. There were Catholic states. There were other states that had other religions that were dominant, and there was a tremendous dislike in that founding generation of having people's tax dollars fund churches. And so that's part of the origin story of the First Amendment and the bar on establishment of religion. And so now we are at a point where having some of these cases come down through the Roberts Court, reversing some of these precedents in terms of money going to religious education, this is the next so-called logical step, which is that now that they've said that you cannot discriminate by denying funds to a religious organization. That was a case that came out of Maine. Now the court is about to decide whether we can be compelled, in essence, to have our tax dollars fund a Catholic charter school in Oklahoma. There was a tremendous story by Heidi Presbala in Politico. I urge you to read it. It talks about the origin of this legal agenda to move this forward and the ties to Notre Dame Law School, to a particular clinic that's funded in part by some of the dark money groups that Leonard Leo has helped move money into these communities to change the law on religion in order to advance his agenda to take down these precedents. And so that case is coming, and that builds on a series of cases that we've seen already, including the case, I think, that Mountain States Legal Foundation was in on Bremerton, which was a case involving a coach praying on a field. The majority opinion in that case said it was just a private prayer. The dissent put the photo of the prayer on the field into the actual court decision to show that that was false, untrue, disputed by documentary evidence. But that case involved, an instance where a coach was having a prayer as part of these football games. And young people could be very, in my view, find that coercive. They feel if they don't pray, will they get to play? If you don't pray, do you get to play? But the Supreme Court, this Roberts Court, decided no, in fact, they were going to protect his right to have that prayer, although claiming it was purely private when that was false, as part of this movement, this revolution in law to take back cases that they think were illegitimate, cases that affirmed the separation of church and state starting in the 50s, 60s, and 70s in this country. So I guess I would focus on that one in particular.
All right, and so, Will, yeah, I mean, the Supreme Court has the case, Ms. Graves was talking about St. Isidore Catholic School versus Drummond, but there's also several cases dealing with firearms, not only the kit case that you were talking about, but they've also got U.S. Rahimi dealing with what people might call red flag type orders. When can you take a weapon away from somebody? There's been cases on interpreting what I'll call law and order type cases where they've interpreted the theft or bribery statute to not include payments made after a decision was made, or that making a statement that's misleading, even though technically true, isn't a violation of the law. So kind of framing the government's ability to prosecute. So there's it seems to be all kinds of trends.
Yeah, so United States didn't file a brief in the Oklahoma charter school case. We don't deal with direct religious freedom issues. We did file a brief in the Washington case, the Bremerton case. That was a couple years ago, where the football coach goes to midfield after the game is over, and students, the allegation is, organically followed him there so they could pray with him. I think the court had trouble drawing a line between that and could the coach cross himself before the key field goal is kicked. Where is it that you have to draw a line between an individual person doing their own individual thing and when they become an employee of the government who's coercing other people? And so they held that private prayer was private enough that the people who were joining him weren't doing so coercively. The Oklahoma charter school issue is a little bit different, though. There's no dispute that it's the government that's funding the religion. And so I don't have a crystal ball. I know my panelists, or I don't actually know that for sure, but they're assuming there's no crystal ball. I don't know that comes out actually in favor of the charter school. In the Carson v. Macon case from Maine that my co-panelist mentioned, that was where the state of Maine was saying, we'll give you a voucher to go to a high school if there's not a private high school, if there's not a public one near you, but it can't be a Catholic school. And the court was very offended by the idea that the program was generally available, except if you wanted to go to a religious school. And that has a different instinct to it. The same idea was in a case called Trinity Lutheran in Missouri in 2017, where Missouri had a program saying, if you want a subsidy for your school playground, we will go ahead and give you a subsidy to put old tires and rubber in your new school playground, unless you're a religious institution. And that, again, had the same feel to it, that there was a discrimination angle. I don't know that that's the same when it's the government who is actually doing the school. On the gun cases, Rahimi came out and backtracked a little bit on where the court was on gun rights. But the key gun case, aside from mine, that the court you ought to be paying attention to is called Estados Unidos versus Smith & Wesson. And this is not truly a Second Amendment case. It's a tort case. So you know how if you get into a car accident or you slip and fall, you might go to court and say, the other person injured me, and I now have a tort. I can go to court and get recompense for the injury. Here, the government of Mexico is suing Smith & Wesson for the injuries that they allege are caused by gun sales in the U.S. that are then trafficked to Mexico. And the lower court, the trial court, said, this can't go forward, it's too attenuated, it's barred by a congressional statute. And the appellate court reversed, saying, no, we think this case can go forward, and now oral argument is before the Supreme Court on that issue. It didn't go very well for the government of Mexico. I just think that the court was intuitively troubled by the idea that the government of Mexico could sue an American company for the gun trafficking in the state of Mexico. But they had some interesting evidence saying that some of these guns have Spanish names, that they're specifically manufactured to appeal to cartels in Mexico. And so there is a direct link between what Smith & Wesson is doing and what is happening on the ground. So I thought it was an interesting argument. I'll definitely be watching for that. And the last one I want to make sure that we mention is the Scrimeti case. So this is a case out of Tennessee. It involves the state of Tennessee banning medical care that's inconsistent with someone's sex. And that ban was upheld by the district court and the appellate court. The Biden-Harris administration appealed it to the U.S. Supreme Court, saying we want you to reevaluate the upholding of this law and strike it down for us. The court took the case, and oral argument was held under the previous administration. And I thought it was the previous Solicitor General under the Biden administration was phenomenal. Her name was Elizabeth Freiliger. She's a very good oral advocate. And her point was just that we want the court to say that this is sex discrimination. So you can send it back down for more analysis, but we want the court to say this is sex discrimination. And she used the analogy of someone coming into the doctor's office and saying, I would like hormone therapy. And if that person is a boy asking for male hormone therapy, that is legal in Tennessee. If that person is a female coming into the clinic saying, I would like male hormone therapy, so the same exact facts, but the sex is flipped, that would be illegal under Tennessee law. And that was the end, really, of the argument, just that very simple mental maneuver. But it did seem like the court was hostile to that argument. It seemed like they were going to uphold the Tennessee law. We don't know. No one knows or has a crystal ball. Because the state was arguing, well, this has nothing at all to do with sex. It's about good medical treatment. And so the state has a role in deciding what treatments people can get medically. The state of Colorado could ban medical treatments it thought were risky if it wanted to. Here, the state of Tennessee is saying this is a risky medical treatment. We have a state prerogative to ban that kind of medical treatment. It'll be very interesting to see how that case comes down, because you could imagine the cascading effects on issues in sports, in preferred pronoun policies, and anything related to transgender issues. If the Supreme Court comes down and says there are two sexes and there's no such thing as transgender identity, or states have a great deal of leeway in regulating what happens with transgender medical treatment, that will have a raft of other consequences. So a very interesting term for sure, and we'll find out by the end of June.
All right, I can actually tell you I've had Mr. Trachman in my court once before, and I can tell you he's an excellent advocate, and when he speaks, he doesn't waste his words. There's a lot that's very dense here to unpack. Ms. Graves?
Thank you so much, Judge. I think that I appreciate your commentary on the not having a crystal ball. I don't have a crystal ball, but I do have a book that is about to come out, and it's called Without Precedent. And it's about how John Roberts and his cohorts have undermined the Constitution and harmed our rights. And it's coming out imminently from Hachette Publishing. And in that book, I take a look at a whole set of cases, the trends on firearms policy. I actually was the Deputy Assistant Attorney General at the U.S. Department of Justice on firearms policy, helped write the National Integrated Firearms Violence Prevention Program after Columbine, after the massacre at Columbine. And helped work on a number of proposals to try to address the scourge of gun violence, which has, affected Boulder, but, cities across our country, synagogues, churches, grocery stores, concerts, everywhere. And so I paid a lot of attention to gun policy over the years, and I know that Mountain States Legal Foundation has weighed in on some of these cases, including the Bruin case, which was the case from a couple of years ago or a year or so ago, in which Clarence Thomas, in his majority opinion, with the Republican appointees signing on, asserted that you could only have a gun regulation that was equivalent to what the gun laws were at the time the Constitution was adopted in 1791. Or at the time that the 14th Amendment was adopted and incorporated the Bill of Rights of the states after the Civil War. And that threw an enormous amount of chaos into gun regulation in the United States at a time in which we actually need common sense gun laws desperately. But that decision, as my panelists pointed out, was moderated a little bit in the Rahimi case last year, where there was a guy in Texas who had a domestic violence restraining order and who was just randomly shooting up at cars and people and the sky, because a credit card didn't go through at Whataburger. He was unhinged. And at that point, the argument through the Fifth Circuit, which is the circuit that includes Texas, that circuit in a decision that was James Ho, who you may have heard of, one of these Trump appointees who's on the Fifth Circuit, basically argued that you shouldn't be able to take away someone's guns just based on domestic violence order, that you need more evidence to deprive someone of their guns. And it went up to court, and it was a close question, this question of, is there a crystal ball or not? What are they going to do? I think that with a election pending, the court decided that it didn't want to actually tell all the women in the United States that we couldn't have gun laws to restrict people who have been found to have, there's evidence before the court showing domestic violence, that they shouldn't have access to guns, since most women who are murdered by their domestic violence partners and murdered by guns. And so they pulled back a little bit and said, in this case, this sort of red flag law, we're going to allow this procedure to go forward, this sort of preliminary order, which in fact Rahimi consented to not having guns while he then continued to fire his guns. They decided to not repudiate Bruen, the terrible, outlandish reasoning that Clarence Thomas put forward in Bruen, but they decided to allow that domestic violence restraining order with a gun prohibition to stand, which was a good thing for public safety. But we are seeing this revolution in the law. And that was a 5-4 decision. And I do want to take a moment to talk a little bit about this 5-4 situation, if you'll indulge me for a second, Judge, which is, that Colorado case, it was 9-0 in rejecting the Colorado Supreme Court's decision to take Trump off the ballot, but it was 5-4 on this idea that the Constitution, that there would have to be a new provision, new procedure to bar someone from the ballot if they were an insurrectionist. And so basically the claim from the 5 members of the majority, which were Roberts, Thomas, Alito, Kavanaugh, and Gorsuch, was that there should be a procedure in order to bar someone from the ballot if they've engaged in insurrection. The 4 women on the court dissented from that, in essence, through their concurrence. They didn't agree to that. But if you look at that 5-4 decision, that was a decision that Clarence Thomas sat on, even though his wife had been actively involved, texting Mark Meadows to try to overturn the 2020 election, had actively sent emails to legislators in Arizona and Wisconsin, there's documentary proof of this, to urge them to put in false electors, basically fake electors, in order to stop the Electoral College vote. And he sat on that case, did not recuse himself. Alito similarly did not recuse himself, despite the fact that there was coverage showing that he and his spouse, over his spouse's home, after his spouse had supposedly flown the flags over their summer home and their regular home that were associated with the insurrection. Did not recuse himself. Had they recused themselves, that decision could have been 4-3 the other way, and who knows what the outcome actually might have been. Similarly, in these 5-4 cases, I just have to mention this one piece, which is Clarence Thomas notoriously has not recused in numerous instances in which he has a personal conflict, including in the Citizens United decision, which was a 5-4 decision that he sat on the swing vote, even though his wife, Jenny Thomas, had just received $500,000 from the billionaire Harlan Crow to start her Tea Party group in anticipation of the Supreme Court's ruling striking down campaign finance laws, which has unleashed this tsunami of money. Had he recused, it would have been a 4-4 decision, and that law would have stood.
All right, I do
Thank
need.
you.
Okay, no, sorry, and we'll switch over here in just a second here, but I messed up. For those of you who don't know, we do use note card system for receiving questions from the audience. At any time, raise your hand, request a note card, and a pencil from one of our producers. My handwriting's horrible, so you've got a low bar, but I do need to be able to read it, so please write legibly. If you're a student, please note that. And the other thing I messed up, so I'll fall on this sword here also, is I was supposed to read that the University of Colorado Boulder is Colorado's flagship university, honors and recognizes the many contributions of indigenous peoples in our state. CU Boulder acknowledges that it is located on the traditional territories and ancestral homelands of the Cheyenne, Arapaho, Ute, and many other Native American nations. Their forced removal from these territories has caused devastating and lasting impacts, while the University of Colorado Boulder can never undo or rectify the devastation wrought on Indigenous peoples. We commit to improving and enhancing engagement with Indigenous peoples and issues locally and globally. CU will do this by recognizing and amplifying the voices of Indigenous CU Boulder students, staff, and faculty and their work, educating, conducting research, supporting student success, integrating Indigenous knowledge, and working collaboratively with tribal nations to enhance our ability to provide access and culturally sensitive support, and to recruit and retain and graduate Native American students in a climate that is inclusive and respectful. So I apologize for not reading that up front. Look, I'm a trial judge, which means I'm not bound by all of the trappings of procedure and this, that, and the other. We're supposed to wait to the last 20 minutes for questions, but man, I love some of y'all's questions. For those of you who don't know, there is a form of judicial review in the United States used to determine the constitutionality of government action that burdens a fundamental right. We generally call this strict scrutiny. And that's always been seen to apply. For those of you built into this question, when it comes to the Second Amendment in the Bruin case, a different analysis was applied, a history and tradition precedent. And so that's the background for this question. Will, do you believe that the history and tradition precedent established by the Bruin Court will be applied to other amendments, such as the First or the Eighth? And what are the possible implications of this test outside of the Second Amendment?
It's a great question. So just for some background, the strict scrutiny test applies in the First Amendment, like free speech. It also applies in the Equal Protection Clause. So if the government wants to discriminate based on sex, it has to meet a higher standard, not strict scrutiny, but a higher standard. And then if they want to discriminate based on race, then they do have to meet strict scrutiny. So Mountain States obtained the ruling from the Supreme Court in 1995 saying, even if you're trying to discriminate against a Caucasian person, the test is still strict scrutiny. Until that time, litigants had said, well, if the victim of the discrimination is Caucasian, it shouldn't be all the way that high at strict scrutiny. The thing about equal protection cases and First Amendment cases is that we have a lot of them. You know, they go back 100 years or more. And so it's hard to disrupt the status quo by saying we're going to adopt a brand new, fresh test that involves history and tradition. Now, that isn't to say that history and tradition won't be a big part of the briefs that are filed before the Supreme Court. I think maybe as an add-on or a sweetener, you'll see a lot of litigants saying, remember how you were so concerned about history and tradition in Bruin? Well, we have a really good argument that this is unprecedented and inconsistent with history and tradition. So I think those will be persuasive arguments, but I don't think that the Bruin test will be adopted there. Why was the Bruin test adopted in the Second Amendment? Well, because there wasn't that much Second Amendment case law. There's a case from the 30s, and then after that, the first real case is in 2008 called Heller, saying that there is an individual right to a firearm. After that, you get one more case called McDonald, and then really nothing else for 12 years. So there's a vacuum in the Second Amendment, and Bruin filled that vacuum by saying, you know, the Second Amendment isn't about balancing. It's not about figuring out whether you've presented a really good reason versus whether you could have done something differently. The Second Amendment says the right to keep and bear arms shall not be infringed. There's no exception for really important things. And so that's why they've adopted the history and tradition test. Just as a point, though, lower courts haven't really done a very good job applying that. One thing that they've done is said, well, the Second Amendment doesn't apply at all to some things. What do I mean by that? Here in Colorado, the court has said the Second Amendment doesn't apply to a firearms waiting period. Why not? It doesn't have to do with keeping and bearing. You might already have guns in your home, and so a waiting period doesn't implicate your right to keep and bear an arm. So there's no Second Amendment right to get a gun with any certain amount of time. What else? Some courts have said, yes, there's a history and tradition test, but we're going to read history really, really broadly. So again, in the District of Colorado, there's a waiting period. What was the analogy? What was the historical analogy to a waiting period? Since the first waiting period anywhere in the United States was in the 1920s. And as my colleague correctly pointed out, Bruin said, we're looking to the founding or to the post-Civil War period. Well, the court analogized to public intoxication laws, saying an intoxication law is kind of like a waiting period because you have to wait until you're sober to buy a gun. Good enough for me, that's the analogy, that's history. End of day, so this is a Mountain States case that we've lost in, that we're appealing. And that's how I think a lot of the lower courts have decided to maybe hoist the court on its own petard by saying, you told us history and tradition, but you didn't say how close history and tradition have to be. The other thing, and I think this is just admittedly clever, is that some law schools, I think Duke or maybe North Carolina, have started a repository of every single local, city, state ordinance on firearms that existed going all the way back to the founding and before the founding, and said, if you are trying to uphold a firearms regulation, enjoy. Here's our repository of all the historical analogs that you might want to draw on. So that's at least clever, right, to say we've done the research. I've also seen courts complain that the judges, no offense, Your Honor, are not historians. And so they can look at the arguments that are before them and say, okay, I think you win, but there might be a treatise out there that you didn't read and couldn't have known about because nobody talked about it. And so already you're starting to see some chinks in the armor with the Bruin test. And as my colleague said, Rahimi, which is this awful case about a terrible person who was guilty of domestic violence and had shot up a Whataburger, and then claimed that he had a right to possess a firearm, and that was an 8-1 decision, not a 5-4 decision, that he didn't have the right to that firearm. And so you're already seeing, I think, some retreading on Bruin, although, just to be honest, I hope not. I think history and tradition are generally okay guides to deciding what the Constitution means, because sitting here today in 2025, we're tempted to think that the Constitution says what we want it to say. We want to prevail in our court battles, our political battles, and so it's good to have some guideline like history and tradition in order to constrain us from just being subject to the whims of our impulses.
And before I switch over, just because we have another question from a student that is related to the question that was just asked, in U.S. v. Rahimi, the Supreme Court diverged a bit from the test for gun laws set by Bruin. Do you think the Supreme Court will abandon, or amend, or stick with the Bruin test going forward?
So just to be absolutely clear, the court in Rahimi, where they say we're going to uphold the denial of this guy's gun rights, relies on Bruin. It doesn't explicitly backtrack on Bruin. But what it does say is that we're going to analogize. As I mentioned before, courts are allowed to analogize. What one said, a waiting period is like a public intoxication law, and it analogized to laws at the founding and before the founding that said we're going to deprive dangerous people of their firearms. And so that's a relatively broad analogy. If a dangerous person can be disarmed and Rahimi is dangerous, then that's the analogy that suffices. And so the government entities that have been trying to embark on more gun control have said, look at Rahimi, we can draw a rough analogy between the historical tradition and what we're doing now. So a sensitive place in the 1790s and a sensitive place in 2025 are both sensitive places, even if they're totally different places, like a subway train didn't exist in the 1790s.
Do you need the first question repeated? Or?
Oh, no, I got it. This manufactured history and tradition test that Justice Thomas imposed in Bruin is one that seeks to enchain us to the meaning of something in 1791 when most of the people in America actually couldn't even vote, and some people were counted as only 3/5 of a person for population purposes, but not for voting. Certainly women couldn't vote then. Similarly, to enchain us to that period over 150 years ago, following the Civil War, that only the laws that exist or analogous then, could apply to us. It is an inherently regressive test. And this test was also, in essence, imposed in the Dobbs case, in the case involving reversing Roe versus Wade. In that case, Samuel Alito, who wrote the opinion, hearkened back to a religious leader in England in the 13th century for the notion that abortion was always a crime. from a religious leader. He also cited someone who was actively involved in burning witches from 300 years ago as part of his citation of history, these people that they're citing as authority for whether we, in the year 2022 or 2023, have a right to access abortion, whether we have a right to not have the state deprive us of our ability to determine our destiny. And in essence, his analysis, this historical analysis, which was much criticized by historians, by legitimate historians, not on the court, is something that was deployed selectively, ignoring other history of access to abortion before quickening, religious traditions like in the Jewish tradition of recognizing women's right to choose, in the Muslim tradition, recognizing a right to abortion before ensoulment at 120 days, estimated by the Muslim scholars, that there's actually a countervailing history that Alito ignored. And so there have been really, I think, legitimate criticisms of this court pretending to be historians. At one point in the Obergefell case, where Chief Justice Roberts was in the dissent, he was citing the Carthaginians, I'm going to mess it up, but basically he was citing, ancient community in America, in the world that recognized marriage between a man and a woman as grounding for why they could not recognize in a civil society, not forcing churches to marry people who are gay, but in a civil society, the ability of people who love each other to get married and have the civil protections of marriage. And Judge Posner, who's one of the noted conservatives, a legitimate, real-deal conservative judge, took Roberts to task for trying to tie our rights to the rights of the Carthaginians, who, by the way, sacrificed children to their gods. So I think that we rely or ground our rights as 21st century Americans in ancient history to our peril.
Well, and I do have a little bit of a follow-up. Look, as a judge, I will often take great care in what I try to write, and I will think it is perfectly clear, and I'm constantly amazed at how someone else will read it and come up with an interpretation that's not at all what I intended. And it's clever. They're smart people. So kind of a piggyback, and I'll just start with Lisa again before I go back to Will. To what extent should, this is another student question, to what extent should history and tradition be balanced with public perception of the Constitution?
Well, I think this question of due process is going to be a very fundamental question right now for America. And the idea that you could possibly get due process through a habeas petition after you're already removed to a torture chamber, basically, in El Salvador, where you didn't get process before you were removed. And the process, even though you're a Maryland resident, has to be in Texas, which just happens to be a great forum for forum shopping. I know that forum shopping is one of the things that some of these groups engage in trying to get their cases before the Northern District of Texas, the Fort Worth Division, in order to get a Republican judge to rule in your favor and then go to the Fifth Circuit where James Ho and some of these other Trump appointees are ready to decimate people's rights. But the fact is that that's not actually due process. And there's been a long history of how do we consider due process. There's a different set of rules at the border when someone's knocking at the door to come into the United States. The rules of the border, Congress has written laws, the anti-death penalty and effective, I forget what it's called now, AEDPA and IRRIA, rules that limited the ability of people to seek a habeas relief or court relief when they're knocking at the border. But when you're in the United States, you're a citizen or a lawful permanent resident or someone who has an asylum case pending, as one of these individuals, I think the person who's described as a gay barber, had an order that basically was protecting his right to be in the United States. There is process, and that process is due before you are removed to a torture chamber in another country. And then to force that process to be only in Texas, because they moved the people around to get to the Fifth Circuit, to get to to get to a Louisiana detention center before they're put on a military plane abroad, to go abroad, that's not due process. I don't think that that's due process, and I think that the idea that the court ruled 9-0 that this was okay. No, the court ruled that of course there's a habeas proceeding because the Constitution guarantees a right to habeas corpus. But that's not the same as basically removing people, snatching them from their homes without any chance to get before a judge, before you get thrown into prison, shaved, and thrown into a room with 153 other people with 2 toilets and 2 sinks with no process. That after the fact process, it's what we need now, but it is not actually, does not comport with the rules of due process. And I think we as the American people, maybe that might have been okay under Clarence Thomas's view of like the hitching post case or what counts as punishment on the 8th Amendment or whatever. Even if someone in like 1791 would have thought that's okay, it is not okay for the United States of America, with its both domestic and international obligations on human rights, to allow this sort of thing to continue and call it due process.
All right, we've got a lot of questions here. Will, your thoughts on history and tradition and public perception of the Constitution, as well as anything in response?
Yeah, Judge, I think your question was how much should we balance one with the other, and the answer is 0%. I mean, the answer to what should public perception mean to the Constitution is very little. I mean, I can present to you my most sympathetic clients. I mean, I just mentioned this gun kit case. My client is a former law enforcement official. She has a hobby of building gun kit parts in her basement, and we went to court on purpose because we wanted to feature her story and the fact that she has every reason to be trusted with these things and not have to be bound by a criminal regulation that was promulgated through the ATF. And so just on those facts, you might say, well, that's a very sympathetic case, and so public perception is that she ought to win that case. No, that's not how we decide cases. That we decide cases by deciding, are you injured? Do you have a right? And can the court remedy your injury by invoking that right? And so we think that we have good answers from history and tradition when it comes to the Constitution and what the free speech clause requires, or the due process clause requires. But the more we try to imbue our current 2025 mentality into those things, the more you're asking for judges to take their own personal views into account. And I thought that my co-panelist was saying we need more constraints on the judges who are on the Supreme Court. They're doing too much political work. They're deciding like a legislature what they're going to decide. And if your response to that is, well, we need public perception and 2025 values to determine what cases, how cases come out, that's going to be a bad result if you think that the Supreme Court is tilted to one political direction or the other. You should be begging for originalism, for textualism, for more constraints on a court that you think is politically motivated. The last thing you want to do is say, you're not bound by anything. The history and tradition of our country has nothing to do with your cases. Decide them as you want them to decide them. The conservative justices that say we're constrained by history and tradition, that's a self-imposed constraint that I would think my colleague would at least want as some guideline. There are organizations, left-wing organizations, doing very good work on trying to invoke history and tradition to their benefit. I mentioned, I can't remember if it's Duke or UNC. There's also a group in DC that's saying in any number of cases, the original meaning of the Constitution gives you the outcome in favor of civil rights or upholding gun control. So it's an interesting dynamic, but going back to the question, the more you focus on how people feel today, the less you're actually going to create reliable, predictable judicial results.
All right, and just because we've got another question from the audience that I'll kind of riffs on what Will was just talking about. History and tradition, consistency. This question asks about precedent. How about precedent and overruling precedent in the name of history and tradition, and the exact words they use here about precedent having more gravitas than current merit is the question. But what about being bound by precedent?
Right, so no judge wants to be 100% constrained by the past, right? You get to the Supreme Court, you're there to decide cases. The fact that someone else decided a case before you is going to be an important factor. You might think about it, you might weigh it, but no one is ever going to say we're handcuffed by the past. And so let's take the example of Dobbs. There you have Roe v. Wade, 1972. It's reaffirmed mostly, although not entirely, in a 1992 case called Casey. And then it gets to the Supreme Court in 2022, And the justices in the majority say, yes, we give due weight to stare decisis, that is, the fact that Roe and Casey exist, but they aren't outcome determinative because we have to review the Constitution anew. We are justices, we are looking at the Constitution, and so maybe there's some really high standard, like egregiously wrong is the phrase that Justice Kavanaugh has said, before I will ignore precedent. But there is a threshold, and that's just going to be true no matter what. Any set of 9 justices are going to say, I may have a better take than what my predecessors came before me. And in that case, remember how difficult the case was for the folks defending Roe. They had to say a document that was enshrined in 1789 and then amended in 1868 preserved a fundamental right to abortion. That's what they were going to the Supreme Court asking to have affirmed, and that's just going to be a hard argument no matter what, right? And of course, five justices said it's not there. One justice said it's not there, but I would cut it back. And then you had the 3 dissenters. But it was interesting. It was a hard argument coming from the defensive Roe side. But I would say, at the very least, you've got the tradition and history to guide you in those cases, and that's better than no constraints at all for judges.
All right, we've got 6 minutes. We've got some rapid fire questions at the end, but 2 minutes.
Okay. Originalism is dead. This idea that these judges, these Supreme Court justices, are following originalism or they're even following the text, they are acting as political actors. This Constitution that I have carried in my pocket for years does not provide immunity from criminal prosecution for a president. It does not. It is not in there anywhere. There is immunity for the speech and debate clause for congresspeople on the floor of the House or the Senate not to be sued for the thing they say on the floor. There is not immunity from criminal prosecution. This Constitution provides expressly that a president can be impeached for high crimes and misdemeanors. This Constitution says that the president's duty in 2 places is to faithfully execute the laws. Nothing could be more unfaithful than breaking them, and to do so criminally. And yet John Roberts and the Republican appointees on this Supreme Court ignored this Constitution, the language in this Constitution, and the history and tradition of America in basically giving Trump king-like powers retrospectively, giving him immunity from criminal prosecution for well-pleaded indictments against him, and have emboldened him, paved the way for his return to office with this emboldened king-like notion that he cannot be held accountable. He's not subject to another election, although he's trying to get around that as well. And all of this is at the feet of Justice Roberts and the Republican appointees in the court who have created this monstrous situation we're in. And they did so in defiance of this Constitution, the words in this Constitution, and history and tradition. And there will be a rebuke of this court, there will be reform of this court, ultimately, because this is an anathema to the very idea of checks and balances, which there's a panel on this afternoon about checks and balances. Checks and balances on the president is one of the most important checks and balances, and I will conclude by saying next year is the 250th anniversary of the Declaration of Independence. I urge you to reread it. One of the grounds for that Declaration of Independence was that the king was failing to abide the laws. We are in a full-blown constitutional crisis. This administration is not fully complying with court orders, and we don't know if it even will if Justice Roberts pulls back from the crisis that he himself has created.
All right, now we are... all right.
Does that mean that you consider yourself a proponent of originalism?
I have been a proponent of the text of this document since I first read it.
Credit for saying that. I mean, a lot of people will criticize originalism and textualism as stalking horses for conservative values. And obviously you're criticizing that there is some hypocrisy between saying you're an originalist and making the decisions that you have. And I don't agree with those, but I recognize the criticisms. But I give you credit for saying you are an originalist, you are a textualist.
I am, and let me just say the Privileges and Immunities Clause of the 14th Amendment has been constrained by the court and has restricted the ideas.
All right, counsel.
Okay. All right. Your Honor, I defer. All right, all right.
All right, I've got a question here that only a lawyer and a law student could love, but we're going to take things back for a little bit. Everyone else, we have questions here about major environmental cases that you'll be watching this year. Do you anticipate the court will continue using originalism to shape environmental policy? This year, the Supreme Court held in the San Francisco case that end result permitting provisions exceeded the EPA's authority under the Clean Water Act. And there's also a case coming out of Eagle County, Colorado, where they're going to ask whether NEPA, the National Environmental Protection Act, requires to study environmental impacts beyond proximate effects over which the agency has regulatory authority. So, Will, this is out of left field, taking a step back, going deep into some wonky weeds, but originalism, environmental policy, Supreme Court. 2 minutes, go.
So generally people distinguish between originalism, which is like the Constitution, and textualism, which is about statutes. They're similar, they overlap, but they're a little bit different. So here the question on NEPA, the National Environmental Policy Act, asks how much you have to study something before you do it. And the environmentalist groups have said you have to study it a lot, and the conservative groups have said not so much. We want to get projects done. NEPA is not a restriction statute, it's a studying statute, saying you have to think about all the environmental impacts before you do it. We filed a brief saying the court ought to take a more narrow view of NEPA, that some studying is required, but not as much as the environmentalist groups normally ask for. The oral argument went very well for our side.
All
Less
right.
than 2 minutes.
1 minute.
Okay. This Supreme Court is assailing our ability to contend with climate change and other environmental disasters. It's done so through reversing 40 years of precedent in the Chevron case in terms of deference to agency regulations. But more than that, a few years ago, the Supreme Court issued a decision that basically said an invented doctrine of major questions, that supposedly when there's a major question, the agencies cannot take this on, Congress has to act first. We'll see if that actually becomes another act of hypocrisy by this court with a president who's issuing all sorts of edicts where Congress has not acted first. That policy, major questions doctrine, that was embraced by Koch Industries and other oil majors as an excellent way for them to assail any environmental regulation they dislike.
All right, I have a yes or no question as we wrap up fast. Do you feel Supreme Court justices should be term limited?
No.
Absolutely.
All right. And I'm not allowed to vote. All right. And I know we're probably at the risk of running long, but I want to squeeze this last one in. If people can do this in like 30 to 45 seconds, because I know this is a huge concern. Enforcement mechanism for the judiciary. If the president loses a SCOTUS case, what stops him from just ignoring it? How is the decision enforced?
Really, 30 seconds on that? Right. So I am firmly committed to our institutions, and I think courts especially are important for our democracy and how we can preserve separation of powers and order. I have confidence, you might think it's misplaced, that President Trump will respect direct orders from this U.S. Supreme Court, especially given that he's appointed 3 of the justices and generally thinks that they have given him in the past a fair shake.
He's threatened to arrest people who criticize his Supreme Court. I don't think that we know what will happen next. And the U.S. Marshals Service technically reports to the Justice Department, which is now helmed by Pam Bondi. And so we are in a serious situation about whether this president will follow an order of the Supreme Court, even a court that he got 3 of the 6 justices in the Republican appointees on that court. So we'll see.
And for those of you that care, Cherokee Nation versus Georgia is the only other case I can find on that issue, so you can go and read it and read the history, Cherokee Nation versus Georgia. Ladies and gentlemen, thank you very much. Thank you.